Yes, hi everyone. This is Dimitris Koulafetis, and during this video, I'm going to illustrate through images and examples the effect of an equitable mortgage on on land, how it can be protected, and what its effect is going to be when the mortgagee wants to realize the wants to realize the land that he accepted as a security for the loan that he has given to a borrower. So we'll start by um, having the land over here. So this basically is the freehold land. So it's called freehold land, and it is registered. It's a legal estate. It's registered, and it's basically registered in its own title. So it's registered in its own title. It's not for the purposes of this video. Let's assume that it's basically not subject to any prior interest. So um, the title here, it has the proprietorship, pro proprietorship register, and it has also the charges register over here. Charges register. Charges register, where every single interest that affects the land is entered, and not only or even state or leasehold unless it is accepted from the purposes of the land registration 2002, Land Registration Act 2002, to be registered. So it can an interest, an equitable interest, or either a legal registered disposition, which is basically a legal estate in that land that's basically needs to be registered. They can all be entered over here, unless it is leasehold over 7 years or over 7 years or more. That can be registered in its own right, and as a part of the registration process, not only is going to be registered in its own right, but it will also have to be register in the charges register, so people that deal with the freehold land will have notice of the leasehold. But anyway, we can talk about the priority and the priorities in registered land, and the dealings with a registered title in another video. So we continue here with the freehold land. So let's say freehold land, and that belongs to Mr. A. So we got Mr. A over here. So Mr. A over here, A, and since the freehold land belongs to him, his name is recorded over here. So this person over here, Mr. A, wants money. He wants money desperately, and in order to get the money, to get that money that he wants, because he's poor, let's say he needs money to he needs to raise a loan in order to pay for his daughter's studies. So he goes to the bank. He goes to the bank. So the bank is here. So here we got the bank. Here's the bank that has loads of money. The banks always have loads of money, and he gets a loan for like £10. He gets a loan for £10, and the bank, because security for its money and takes he basically puts the freehold land as security for the £10 as security. Since the freehold land costs £7, so it's good value for money basically. In case he defaults with the loan and he cannot pay the £10 back to the bank is going to seize that land and is going to sell it in order to extinguish his debt and the interest accrued thereafter. So we'll already have £7 or even more if the the land appreciates in value in the coming years. So he basically gives the bank a mortgage. However, as we know, mortgages do convey some type of an estate in land, not the entire estate, but they do create a proprietary interest. Also, they are of a very drastic nature. Somebody puts this land as security, so because of the proprietary right that they convey to the bank or any other lender, that he can basically seek possession of the land. He can just sell it to anyone, and a lot of people are getting affected when they can't pay, when they are unable to pay their loans back to the bank, and as a result, families getting affected. They might just end up in the streets, and etc., etc. So it needs to follow some requirements by the law in order to amount to a legal mortgage. Because if it doesn't and falls short of the requirements that are set out by the law, it will just be an equitable mortgage. So let's say that for many purposes, for many reasons, it is basically done informally. So but it is basically done informally, and it is though made by deed. A deed actually gives you a power to sell, but it doesn't convey a legal mortgage. It conveys an equitable mortgage because the formalities have not been attended to by both of them. So first stage, second stage, Mr. A gives the bank an equitable mortgage. And accordingly, the bank enters that mortgage over here. It enters it in the charges register. It cannot be registered in its own title. So the equitable mortgage is actually protected in any a person that acquires registrable disposition for value will take notice of that equitable mortgage, and it will be binding on him. When we say binding on him, the bank is going to be able to force a sale of the freehold, and accordingly demand from Mr. A to convey the legal estate to it. Now we're going to come to this in a minute. So let's say Mr. A unfortunately loses his job and he defaults on the £10 loan. So the bank rushes to get its security. It rushes to get security here. Well, here it rushes to get it no matter what. It just runs quickly to acquire it and sell it. Now, let's say there's a power of sale because it's made by deed, the equitable mortgage. Because if it's not made by deed, the bank's gonna have to go through judicial sale. It's gonna have to apply to the court to sell the property. But there seems to be a problem here because the bank will only be able to sell. We only be able to the bank. The what is subject basically to the mortgage is an equitable estate. Is an equitable right. The legal right over here has been is still with a gentleman over here. Is still with Mr. A. The bank, what the bank does is basically it acquires it basically sells the freehold land, let's say. It sells the freehold land to P, which is a purchaser, and let's say Pi over here, which is the purchaser. He actually receives an equitable interest. Now the question remains, what can he do in order to get the legal interest conveyed, be vested actually in him? Because he doesn't want to have an equitable interest. He doesn't want to have an equitable estate, and the reason is an equitable estate cannot be it cannot be entered with its own title. So no own title, just like the freehold here. It's not gonna be an own title, a title in its own right, because he's got like an equitable charge, an equitable interest, an equitable mortgage, which basically is gonna enter again the charges register in order to be protected from registered dispositions. Because this guy over here, still this person over here, he has the legal estate, and he can vest it to, let's say, another purchaser. He could vest it to another purchaser and create all sorts of trouble. I mean, this guy then is gonna have to go to court, and he'll have to enforce his rights that are being protected by virtue of having entered a notice against another purchaser. Let's say against the P1, Pi 1, who acquires a registrable disposition for value, but with notice. Therefore, P1 is going to be bound by his interest. But however, this is going to be still a source of anxiety and a lot of problems for him, because what if he wants to sell the land further? He will not be appearing as the registered proprietor, because it cannot be because the freehold land, the equitable estate in the freehold land, cannot be registered in its own right. So this cannot be done, and it's people will not want a property that they cannot see what kind of interests are recorded in it. So there's still this problem that needs to be solved. Well, basically there are two ways that the equitable mortgage can that person over here, that the bank can sell, and he can sell and vest actually the illegal estate to the purchaser, basically. So yeah, there are two ways that this can be beaten, provided that there's a power of sale in the power of sale that is basically made by deed when the equitable mortgage is created. The first one is, so we got the fifth stage, and the fifth stage over here deals with the what's the title? The fifth stage deals with, let's say, how the equitable mortgagee can convey, vest the legal title, because as I just explained, it's having an equitable estate, it's not of much of value, I mean, practically, because of all this technicality shortage. The legal estate needs to be vested to the new purchaser. it can't just remain with the old one, because it had just remained because of the irregularity in the that actually happens when equitable mortgage is acquired. So, provided that there's a deed, there is a statutory power of sale. So there are two ways: either with a power of attorney, and the power of attorney is given by by him. It's given by the borrower to the bank. To the bank, and since he has a power of attorney, he can convey the legal estate, legal estate in pi, so he can finally um, be registered with his own name. And the second way is that a clause inserted in the deed that states that the borrower basically holds the land in trust for the bank. So there's a trust. The bank is equitably interested in the freehold land, and also give the power to the bank, to the beneficiary of the freehold, not of the mortgage. It's got nothing to do with the equitable mortgage. Basically, gives it power over the freehold land as a beneficiary. It gives him also a power. This is very basic, very important. A power to appoint himself, to appoint itself. The bank can appoint itself as a trustee in replacement of the borrower. So now it can definitely vest here the legal estate through that second way to Pi, the purchaser, and he can finally register himself here as the registered proprietor of the freehold land. So he will be more trusted, and he will not be in danger, not be risking having his dream home that he invested so much money fraudulently or in any way sold by the borrower to someone else. However, if it's sold to someone else, we already explained that that registered proprietor, through that transfer of the legal estate, will be bound. Let's say P1 is going to be bound by by the person that has been delivered the equitable estate. So when he does, so it's going to be here actually, equitable mortgage. Let's say if that second hypothetical scenario happens, the estate contract, because it's going to be through an estate contract, and since it's not going to be a conveyance of the legal estate in at first, so there's not going to be any formalities, and when the bank can convey the legal estate to the new purchaser in the name of A, that's how it's basically done. He will be able to register himself as the registered proprietor. So the this P1 is always going to be bound by the estate contract. So even if he acquires anything, he has notice by virtue of section 29 of the Land Registration Act 2002. So if there is no, however, the fifth scenario here, I'm not talking about a stage, I'm talking about a scenario again. So 5, let's say that there is here five, no, six, I'm sorry, we've already been to five, six. If there is no deed, there is no statutory power of sale. In this way, in this event, the bank is gonna have to go to the court, and will have to ask for a judicial sale, and provided that the equitable principles are satisfied, and I can see no reason why they wouldn't be satisfied, because there's no issues of priority or anything with regards to this clean cat scenario that I just illustrate. It can ask for the conveyance of the the equitable estate as well as the legal estate, because the conveyance of the equitable estate is of not too much value if the legal estate is not going to be conveyed to the purchaser, basically. So thanks very much all for your time. I hope that you understood and that you enjoyed the video. I tried to break things up as much as possible, because I know the intrinsics and the complexities that are involved in matters relating to the law of real property. So don't only count on this video, it's for informative purposes. Do your own study, read as much as you can from reliable and from easy to understand sources, and I'll see you in my next video. This is Dimitris Koulafetis. Thank you.